International, the IUCN World Commission on Environmental Law, the National University of Singapore Asia Pacific Center for Environmental Law, LexisNexis, Macquarie Uni Center for Environmental Law, LawAsia, the Indonesian Center for Environmental Law, the World Youth for Climate Justice, the Philippines Association of Law Students, and the Climate Reality Project. I would like to extend a very warm welcome to all of you to this first session of the conference. My name is Georgina Lloyd, and I'm the Regional Coordinator for Environmental Law and Governance in the Asia Pacific Regional Office of the United Nations Environment Programme. And I am based in Bangkok. During this session, we will hear of the role of environmental human rights defenders. We'll hear about strategic lawsuits against public participation and other emerging issues between human rights and environmental protection. Human rights and the environment are intertwined. Human rights cannot be enjoyed without a safe, clean, and healthy environment. And likewise, sustainable environmental governance cannot exist without the establishment of and respect for human rights. The recognition of environmental rights is a cornerstone of environmental rule of law. And in recent years, the number and scope of international and domestic laws, judicial decisions, and academic studies on the relationship between human rights and the environment have grown rapidly. Further, environmental human rights defenders play an important and a legitimate role in upholding, implementing, and advancing environmental rule of law. Despite this increased recognition of their role, one of the biggest challenges facing the achievement of sustainable development and countries successfully addressing the triple planetary crisis of biodiversity loss, pollution, and climate change are threats to the life and liberty of environmental human rights defenders. All over the world, there is growing global concern over threats, intimidation, attacks against, and the killing of environmental defenders, as long with the bringing of strategic lawsuits against public participation to silence them. This sits alongside a deeper appreciation of their vital role in promoting a healthy environment. The UN defines environmental human rights defenders as individuals and groups who in their personal or professional capacity and in a peaceful manner strive to protect and promote human rights relating to the environment, including water, air, land, flora, and fauna. UNEP considers an environmental defender to be anyone, including groups of people and women human rights defenders who are defending environmental rights, including constitutional rights to a clean and healthy environment, and when the exercise of those rights is being threatened. Today, in this session, we're going to hear from 4 incredible speakers who will delve deeper into the challenges and the opportunities to advance environmental rule of law through a rights-based approach. Throughout the session, I really encourage you to put any comments or questions in the chat box, and we'll do our best to address as many of these as possible at the end of the session. So without further ado, I would now like to introduce our first speaker. Our first speaker is Victor Bernard from the Raoul Wallenberg Institute. Victor is a program officer who specializes in the interlinkages between human rights and the environment. In this capacity, he leads many of RWI's research and capacity development initiatives in Asia and the Pacific to strengthen knowledge base on human rights, gender equality, and the environment. Victor is going to speak on the emerging tensions between human rights and environmental protection. Thank you very much, Victor, and the floor is yours.
Thank you so much, Georgie, for that very kind introduction, and also for inviting me to speak here at the 2nd ASEAN Environmental Law Conference. I will start my presentation by first demonstrating the potential conflicts that have emerged or could emerge between human rights and environmental law, which I will follow by presenting some solutions to mitigate and address these conflicts, including the protection of environmental rights defenders. Asia and the Pacific faces a number of unprecedented environmental crises that Georgina just mentioned. These include the biodiversity crisis, air pollution crisis, and the climate emergency, all of which adversely affect life, well-being, and the ecosystems and natural resources upon which we depend, which in turn infringe our full enjoyment of our human rights. Addressing environmental degradation and mitigating and adapting to climate change is no longer a choice, but an urgent priority to save lives and protect human rights. The premise that human rights and environmental protection are mutually reinforcing is widely recognized and has been leveraged to legitimize the human rights argument to pursue environmental and climate change cases against governments and corporates around the world, as well as catalyze action. However, the question remains, are environmental law and human rights always mutually reinforcing? In practice, research and case law have shown that environmental protection laws and measures frequently collide with various human rights. A typical example of such conflict concerns the creation of protected areas, including national parks, wilderness areas, and natural reserves, which form the mainstay of biodiversity conservation and are part and parcel of efforts towards conserving nature and the services it provides us. On many occasions, these protected areas have been established and maintained using a so-called fortress conservational approach, which refers to practices intended to protect biodiversity in an exclusionary way. That is, in a way that separates nature from humans. According to Professor David Boyd, the UN Special Rapporteur on Human Rights and Environment, such an approach is underpinned by the misinformed premise that successful conservation outcomes require pristine wilderness that is free from human inhabitants and neatly isolated from human contact. Fortress conservation has, as a result, dispossessed indigenous peoples and other local communities from their homes and ancestral lands. It has also criminalized their traditional livelihoods, violating their rights to life, health, water, food, and an adequate standard of living, as well as non-discrimination and their cultural rights. Additionally, fortress conservation has militarized conservation, whereby authorities are given power to use arms with immunity to protect the environment, leading to several violent encounters between, among many others, environmental rights defenders and park rangers. Another conflict area pertains to planned resettlement of people who are living in ever-growing locations that are highly vulnerable to disasters and other climate change impacts. Planned resettlement is widely seen as an effective adaptive measure aimed at moving populations out of harm's way, or to make way for climate mitigating or adapting programs aimed at strengthening resilience and reducing vulnerability to climate change in line with Article 7 of the Paris Agreement. However, despite these good intentions, planned resettlement often comes at a high human rights cost if done incorrectly and not used as a last resort. This impinges particularly on the right to adequate housing, whereby people who are resettled ends up either homeless or worse off in terms of living conditions. There have also been reports that a series of resettlement programs have violated the right to not be forcibly evicted, which forms an inevitable part of the right to adequate housing. These violations were especially grave in cases where the awareness of impending climate change danger was low amongst the affected population and where resettlement decisions were taken without the free, prior, and informed consent of the affected populations. This therefore begs the question, how do we help mitigate the tensions between human rights and environmental law? Firstly, we must ensure that actions designed to address environmental degradation and/or mitigate and respond to climate change incorporate a rights-based approach to render more effective, efficient, and equitable pathways to safeguarding the planet. The Raoul Wallenberg Institute recently published a discussion brief on pathways to just, fair adaptation, which offers concrete guidance on the elements of a rights-based approach and how they can be directly integrated into the different phases of climate change adaptation, planning, and programs. One particular element of this rights-based approach that I would like to stress in this event is the procedural one, which includes the need for access to information, securing free, prior, and informed consent, and meaningful participation. But this also extends special protections to environmental rights defenders. Environmental rights defenders are crucial in raising awareness on the harm to people and nature engendered by well-intended environmental protection programs and underscore the disproportionate costs borne by the most vulnerable to achieve the global targets on biodiversity and climate change, despite contributing the least to both. Other participatory techniques that should be considered include overlapping usages and co-management of land to guarantee that, for example, conservation does not hamper the rights of people living on and from the land. It will also ensure that customary tenure systems anchored in both traditional and contemporary knowledge, held mostly by indigenous groups, smallholder peasant farmers, and other vulnerable communities, are leveraged. Local communities and indigenous peoples are considered more effective effective custodians of vast ecosystems than their governments. Secondly, judges play a crucial role in balancing between the enforcement of environmental laws to prevent further degradation and tolerating a relative amount of environmental harm in the interests of benefiting a specific human right. As mentioned earlier, the burden of adapting to new environmental standards is in most cases disproportionately borne by the most vulnerable communities, many of whom are forced to sacrifice their livelihoods and way of living to achieve the international environmental targets, such as protecting at least 30% of the planet by 2030. Whilst major corporations continue to damage the environment with impunity. Furthermore, courts will also be the guardians that prevent slap suits or potential slap suits against defenders from governments and non-state entities aimed at stifling dissent on the adverse human rights impact of million-dollar environmental programs that have been implemented without a human rights lens. That's it from my side. I look forward to hearing more from my colleagues on the specific issue of defending the defenders. Thank you.
Thank you very much, Victor. And a reminder to everyone, please do put any questions that you might have throughout the session in the Q&A box, and we will come back to any questions that are raised at the end of the session. Victor, you raised some really important points about the inherent tensions between certain models of conservation and a human rights-based approach, and the necessity to adopt a rights-based approach to ensure that environmental rights are upheld, protected, and promoted, and also that we are able to effectively address the threats of biodiversity loss and climate change and pollution. So now we're going to turn to our next speaker, who is Katia Chirizzi, the Deputy Regional Representative of UN OHCHR, or UN Human Rights, and the Southeast Asia Regional Office based in Bangkok. Katia's worked with UN Human Rights in several capacities in Nepal, Sri Lanka, Maldives, and in Geneva on the protection and promotion of human rights, both in conflict and post-conflict settings, including looking at contexts of transitional justice, equality, non-discrimination, humanitarian action, land rights, business and human rights, climate change, and environmental rights. Katia is going to share more about the need to defend environmental defenders and the role that they have in advancing environmental rule of law. So thank you very much, Katia. The floor is yours.
Thank you very much, Georgie. Good morning to everyone connected. It's really a pleasure on behalf of the Office of the High Commissioner for Human Rights to join you all today. I'm gonna go through a brief overview of, as you say, the role of environmental human rights defenders, but in particular also focusing on the normative framework related to it. Next slide, please. Only in 2021, 358 human rights defenders were targeted and killed for their peaceful, powerful human rights work, according to Frontline Defenders Global Analysis. The highest number of killings occurred in America and in the Asia Pacific region to follow. Defenders, as was already recalled this morning, working on land, environmental and indigenous people rights, whose human rights activities disrupt the economic interests of corporations and individuals in mining, for instance, logging and other extractive industries, accounted for 59% of the total killing. Alarmed by these statistics, very recently, on 9th of March 2022, there was a side event at the 49th session of the Human Rights Council, co-organized by our office and Sweden. And this event was really inviting representatives from government and other key stakeholders to reconfirm the international community's commitment to defend and support environmental human rights defenders and muster support to increase states' action to promote and protect their rights. And what you have here is a quote from the intervention of the UN Human Rights Commissioner for Human Rights. Next slide, please. Now, before recently, Georgina referred to the definition and the term of environmental human rights defenders. And this term was first introduced by the former UN Special Rapporteur on the situation of human rights defenders in his report to the General Assembly in 2016. So it would be important to revisit for a moment where that definition came from. And according to the former Special Rapporteur on human rights defenders, land and environmental rights are interlinked and often cannot be separated. The two broad categories of defenders advocating for the environment and for land rights are often characterized as land and environmental human rights defenders, or environmental rights defenders, or just environmental activists. Therefore, his report defined those defenders through the inclusive term of environmental human rights defenders. Environmental human rights defenders are identified above all by what they do, and they are characterized as such through their actions to protect environmental and land rights. The environmental human rights defenders may work as journalists, activists, lawyers who expose and oppose environmental destruction and land grabbing. However, they're often also ordinary people living in remote villages, forests or mountains, who may not even be aware that they are acting as environmental human rights defenders. And in many other cases, they can be indigenous leaders or community members who defend their traditional land against the harms of large-scale projects, such as, for instance, mining and dams. Next slide, please. Environmental human rights defenders have the right to exercise such fundamental freedoms as the right to freedom of expression, privacy, association, and peaceful assembly, as enshrined in the Universal Declaration of Human Rights and the International Covenant on Civil and Political Rights. So today I will use this opportunity to briefly revisit the normative framework of the main international instruments that guarantee the rights of environmental human rights defenders. With regards to exercising the right to protect environmental and land rights, Article 1 of the Declaration of Human Rights Defender further holds that everyone has the right, individually or in association with others, to promote and strive for the protection and realization of rights and fundamental freedoms as at the national and international levels. Next slide, please. Now, speaking out and speaking up for environmental human rights can and does come at an enormous cost, both to individuals and communities. And there was already reference to a number of human rights violations and abuses that come into play. Environmental human rights defenders are subjected both to killings and smear campaigns, just to mention a few. Judicial harassment is a trend on the rise. And this is extended also to their family and community members often as a way to silence their voices and put pressure on them. Now, the state's primary responsibility to protect the right to life, liberty and security of a person is enshrined in Article 6 and 1 of the International Covenant on Civil and Political Rights. And this includes both negative and positive aspects. On the one hand, states must refrain from violating the rights of human rights defenders. And on the other hand, they should act with due diligence to prevent and investigate human rights violations and bring the perpetrators to justice. Next slide, please. So this follows with the right to be protected, which again is enshrined by Article 6 of the International Covenant on Civil and Political Rights. And for example, law enforcement officials must be properly trained to deal with peaceful protests so that they can apply proportionate use of force and provide protection to peaceful protesters during assemblies. On the other hand, states should also put out protection measures in place before harassment and violence occurs. So both reacting to violations, but equally importantly, to prevent violations from occurring, all being part of the right to be protected. Next slide, please. So then we get into the right to an effective remedy. And if we unpack it for a moment, what does it mean? The state's obligation to provide an effective remedy for violations is affirmed again in the ICCPR. And Article 9 further holds that defenders have the right to benefit from an effective remedy and to be protected in the event of violations. So prompt and impartial investigations into violations, prosecution of the perpetrators regardless of their status, provision of redress, including appropriate compensation to victims, and enforcement of the decisions or judgments are fundamental in order to ensure the right to an effective remedy. Failure to take these actions leads to further attacks against offenders, resulting in a climate of impunity. Next slide, please. So if, again, we look at the normative framework, there are a number of state obligations which come into play. And some of these were already referred to. So procedural obligation of states to assess environmental impacts on human rights, to make environmental information public, to facilitate participation in environmental decision-making, and to provide access to remedies for environmental harm. There are also substantive obligations of states to adopt legal and institutional frameworks that protect against environmental harm, including the harm which is caused by private actors, and I will come back to this. And then non-discrimination and other obligations of states related to the protection of groups in vulnerable situations, including women, children, and indigenous people. And there was already a reference made earlier to the right to obtain free, prior, and informed consent when it comes to the specific context of large-scale development projects, for instance, and their impact on indigenous people's rights. Next slide, please. So I mentioned the role and the specific obligation of non-state actors. And while states are bound by the international human rights law, non-state actors are required to respect human rights, including the right to defend environmental and land rights. Transnational corporations and other business enterprises must respect human rights as set out in the UN Guiding Principles on Business and Human Rights. The principles require that companies identify and assess any actual or potential adverse human rights impact through meaningful consultation with potentially affected groups as an integral part of the responsibility to respect human rights. Such impact assessments should be carried out not only at the start of a new project, for instance, but also throughout the life cycle of the project prior to any significant changing in the operating context. Now, let me conclude. The next slide, please. By looking at the factors which contribute to the vulnerable situation of environmental human rights offenders, which are the result of failure of duty bearers to comply with the rule of law themselves, or to enforce it against either. And this failure tends to take at least three forms: the direct involvement of state officials or representatives in violence against environmental human rights offenders, the failure of governments to investigate and punish harassment and violence directed at environmental human rights defenders, and the adoption of and implementation of laws that restrict space for environmental human rights defenders to speak, protest, organize, and take any other actions in violations of the environmental human rights defenders' rights to freedom of expression and association. So I would really like to end by emphasizing that protecting the environment goes hand in hand with protecting the rights of those who defend it. And their voices must be heard and protected. And ending with the words of the UN High Commissioner for Human Rights recently at the Council, I would like to reiterate how we must have zero tolerance for killings or threats against environmental human rights defenders and jointly take action against them. Thank you.
Thank you so much, Katia. And I think your presentation was critical in really outlining that the normative framework and the links, particularly on the role of duty bearers to uphold environmental laws and to ensure that the rights of rights holders are respected and protected. Next, we are going to hear a paper by Agung, Wardana, and TWongkar. Agung Wardana is assistant professor at the Department of Environmental Law, Universitas Gadjah, Mada in Indonesia, and Alexander van Humboldt Fellow at the Max Planck Institute for Comparative Public Law and International Law in Germany. Etheldreda, or Chenny, is known for her central works in handling and voicing environmental governance and climate justice issues. As head of the Environmental Management and Climate Justice Division of the Indonesian Center for Environmental Law, Chenny actively engages in the environmental movement to pursue climate justice in Indonesia. Chenny is going to be presenting their paper on Indonesia's SLAP landmark cases and what we can learn for the protection of environmental defenders. And I think this really goes deeper into some of the issues that both Victor and Katia have introduced, and looking at how anti-SLAP measures can be used to support the work and the role of EHRDs. So thank you so much, Agung and Chenny. The floor is yours.
Okay, thank you so much, Georgie. I will start the presentation first. So greetings, everyone. In this opportunity, me and my colleague, Mr. Wardana, are going to talk about Indonesia's SLAP landmark cases as a way to learn more about the characteristic of SLAP cases in Indonesia with the future protection needed to protect the environmental human rights defenders derived from the verdict's decision in Indonesia. So next slide, please. So it has been a public knowledge that Indonesia has experienced quite a number of SLAP cases despite the adoption of an anti-SLAP provision in Article 66 of the Environmental Protection and Management Law. Moreover, unlike its origin of concept that firstly developed by Pring and Cannon, the nature of SLAP cases in Indonesia, which I also believe applies to most of SLAP cases in ASEAN, involving criminal procedures in that were in the form of trump of crimes or like excessive treatment to the victim to give an exaggerated effects to shield their activism. Responding to that, in this opportunity, we would like to present two of landmark cases in Indonesia, which may provide a glimpse of hope in the protection of environmental defenders from legal intimidation. One is in a criminal division and another is in civil realm. Next slide, please. So first of all, I will talk about the case of Robandi. This is a criminal case that happens between 2020 until 2021. For the nature of cases, there is Robandi and 5 other neighborhood leaders in Kenanga district, where they were against the operational of Bangka Asindo Agri Company that produce odors that can be categorized as an air pollution. Then they refused the BBA's corporate social responsibility program by the company and then resigned from their position as the community leaders. After the resignation, they signed a letter to gather villagers for a meeting into preparing a class action lawsuit against the company. They were then convicted by the district court of Sungai Liat, located in Sumatra, for committing a crime of forgery and punished for a month in prison. But in the appeal, the High Court of Bangka Belitung nullified the verdict and then decided to discharge the defendants. Now, why is it the case significant? Next slide, please. Okay, so we see that the court used a consequentialist or unjustified means reasoning that the defendants were acting in order to protect their rights to a good and healthy environment. The judges in this case recognize and admit the criminal act in the form of forgery conducted by Robandi and his friends, but reckon that the action where they did sign invitation for a villagers meeting in preparing a class action lawsuit were being done for a greater purposes, which is the fulfillment of community rights to healthy environment. Therefore, the defendant's action can be tolerated as their efforts must be interpreted as a form of participation against this the BAA's company's pollution itself. This fills the loophole of the anti-SLAPP provision in Indonesia by putting it as a ground of justification in criminal defense. So in this case, we can see that the judges makes law and set a clear jurisprudence on anti-SLAPP handling treatment on criminal cases. Moreover, another good point of view that also Katia has mentioned before, that in this case, the court granted a legal remedy as a form to tackle identity transformation resulted from the SLAPP effort by ordering to recover the rights of citizens of their dignity due to the SLAPP cases that were brought upon them. I think this is a very considered as important measures, because as one of the purpose of SLAPP cases in Indonesia is to tarnish the good name of the movement leader so that the people do not trust him anymore. So this is like a very good step ahead. Next one is the civil cases of the Willy, Suhartono, and Haji Rudi that happened during the time of 2013 until 2014. Next slide, please. So the nature of cases that the director of Panggon Sarkarya Sukses Mandiri or SSM company, Willy Suhartono, in this case, filed a lawsuit against Haji Rudi on the basis of Article 1365 of Civil Code regarding an unlawful act. Previously, Haji Rudi filed a letter of complaints and reports to several government institutions and held also a demonstration with the impacted residents of project development to express their objections to the construction of Raja Batu Resort, one of the building project of SSM company. Interestingly, in his defense, Haji Rudi clearly stated that his actions were carried out based on his right to public expression, and the plaintiff effort in suing and seeking legal remedies from him is a form to silence environmental activists, as it carried economic and also political motive behind the suit. Haji Rudi also submitted a counterclaim on the same trial, conveying the facts related to the construction of the Raja Batu Resort, which violates a considerable number of environmental protection regulations. In the decision, the Malang District and Appeal Court then decided that the plaintiff is the one who committed the unlawful act, as his action carried out a potential impact on causing potential loss to the ecosystem of Gemulo Springs. Therefore, this potential impact should be taken into account in the futuristic point of view and precautionary measures manner in favor of the preservation of the environment itself, so that the ecological disaster can be prevented. So why is this case significant? First, next slide, please. Yeah, despite the law enforcers apparatus' lack of understanding of anti-SLAPP at that time, but the SLAPP effort by the defendant was then tackled by the judges due to his support for the environment or his pro-nature natures. This was proven by his recognition towards the potential suffered damage of Gemulo Springs and highlighting the participatory principles of citizen as a basic requirements for a development. So, and then the second one, the judges also combines both substantive and procedural rights to environment as a consideration in deciding cases, as he correlates the impact of Gemulo Springs to the community effort in preventing it. The third one, the judges that also expands the scope of participation that considered as legitimate. That includes series of action of public participation outside the court, such as demonstration and also filing letter of complaint, as also a form of expression that is protected by the law. This is quite a landmark logic of thinking, because the current law in Indonesia only recognize efforts of participation made through the courts as a form of participation protected by the law. But unfortunately, the judges does not grant compensation or legal remedies as the decision is not based on anti-SLAPP. The judges considered it is very necessary to have an evidence of the actual loss suffered by Haji Rudi that can be clearly quantified and calculated, which are not usually the case for SLAPP victims. Okay, next slide, please. So I'm going to explore more about the prospect for future protection. First, for the criminal case handling. So from the procedural aspect, we know that from the Romania case, the decision on SLAPP were made in the end of the trial, even in the Court of Appeal. Therefore, the chilling effect of SLAPP had already occurred during the long process, and there is the need to improve the procedure to effectively prevent SLAPP from the very beginning, be it in the form of enacting a new institution or just strengthening the existing institution. But the important thing is also to renewing the problematic legal procedures. Now, from the substantive aspect, we think that there is the use of the conditio sine qua non doctrine to put the criminal charge within a wider context. We think that in this case, every fact is considered by the judge, so no fact get left behind, including the background on why the defendants decided to commit the crime. The judges here restores and combines the legal and political context in making their considerations, so that they get more holistic understanding towards the case that's been brought upon them. And we think that this is quite a landmark because in Indonesia, most of the judges are quite having being normative and conservative kind of thing. And the last one is the strengthening of anti-SLAPP provision. In the Romania case, sets the jurisprudence to clarify the ambiguity whether the anti-SLAPP provision should be regarded as a justificatory defense or executory defense. This case presents a justificatory defense as a proper defense base for SLAPP cases that can be followed later on the next cases. Next one is the prospect for future protection for a civil case handling. Next slide, please. Deriving from Willy Suhartono case. So from the procedural aspect, we know that the decision on SLAPP were made in final verdict. We think that there should be a strong mechanism accommodate in civil procedural regulation so that the SLAPP cases could be dismissed in the interim decision that serve as a final verdict. This was like the concept of motion to dismiss in the US or in the Philippines law. The second one is the substantive aspects. We also think that in this case, the judges use the conditio sine qua non doctrine to put the civil charge within a wider context, as the judges also recognize and interlink the fact that the resort development was violating the environmental regulation and has the future impact on the source of clean water from the surrounding community. The second point, learning from Willy Suhartono and Haji Rudi cases, there is a need for anti-SLAPP norm and characteristic to be stated explicitly in one norm or regulation, so that the law enforcement apparatus, particularly the judges, could easily and more convenient to interlink the facts of the case to the anti-SLAPP provision. Thus, will give more legal certainty for the application of anti-SLAPP in the case settlements and enforcement in court. As in this case, although the defendant has elaborated extensively about anti-SLAPP, the judges were hesitant to base his decision on anti-SLAPP clause due to its folk norm. Okay, and the third one and the last one is the strengthening anti-SLAPP provision from the Willy Suhartono and Haji Rudi cases. This case has set a jurisprudence for the legitimation of series of effort outside the court to be protected under the law. This should be implemented in the series of policy and also legislation to create a wider understanding of public participation scope that is protected by the law. So not only on the base of legal or a court way only. And the second one is to create the consequently linkage that the anti-SLAPP will be automatically implemented when the three types of community rights of access, which is we all talk about in Aarhus Convention, are not fulfilled and got violated. I think that's all for me. Thank you so much for the time, and we're looking forward for the discussion in the next session. Thank you. Back to you, Georgie.
Thank you so much, Chenny, for that presentation, and the paper from both of you, Agung and Chenny, really outlining some of the core anti-SLAPP provisions and the legal foundations to support the role of environmental human rights defenders.
Yes. Thank you so much. Thank you.
So we're going to move now to ask a few questions of our speakers, because we did have a final speaker in our panel, but I think that they are still struggling a little bit to join us because of some technical issues. Oh, actually, I see that Sypha is with us now. Sypha, are you able to unmute and turn on your video? Sypha, can you try speaking for me?
Yes.
Fantastic.
Good morning.
Great.
I try to use to open my camera, but unable to start video. I don't know why.
No problem. Well, our final speaker is Dr. Sypha Chanthavong from, he's an environmental law lecturer and director of the graduate programs of the Faculty of Law and Political Science at the National University of Laos. Dr. Sypha's research interests focus on environmental and natural resource laws, particularly water, land, forest, and local people's rights related to natural resource management. I'm very happy to give the floor to Dr. Sypha to speak to us on the ownership of forest carbon rights in legal and empirical studies in Laos PDR. Sypha, you have 10 minutes and the floor is yours.
Thank you so much, Gadjah, for your short interview, and good morning. Or I would like to present about 10 minutes about my research topic on the ownership forest carbon right in legal and empirical study in the Laos PDR. Yes. Do you see my screen, right?
Yes, we can see your screen, but can you pop it on PowerPoint mode? Can you put it on full screen? Yes, that's it.
Yes. The topic that I would like to present to you, there are 5 topics here. Start from the introduction and then acknowledge forest carbon and forest carbon ownerships in terms of Laos, in the law of Laos, and then talking about the forest carbon ownership in accordance with the Laos PDR law and public claim to the forest carbon, because now the forest carbon is very hot topic in Laos PDR now, and then come up with the conclusion. Come to my introduction. Right? In here, I mean in Laos PDR, the natural resource, including the soil, mineral, water resource, air, forest, non-timber forest product, aquatic animal and wildlife, etc., is belong to the national community or belong to the state, and managed by the state as defined in the 2015 Constitution of the Laos PDR. However, even the Constitution provide about the national community in terms of the natural resource, but is quite contradict between the law and the Constitution of Laos PDR, because according to the Article 4 of the Forest Law in 2019, state that the natural resource and natural forest and forest land is the property of the national community, but forest and tree planted with the labor of an individual, legal entity, organization, or investor in those areas designed by the forest and forest land management organization, so become the property of the single individual, legal entity, or organization or investor, which means that if you plant the tree, right, the tree is belong to you. Then how about the carbon forest? Is belong to you or not? Is quite interesting to study. That is my introduction. And then talking about the acknowledging of the forest carbon and forest carbon ownership. Yes. It can be said that forest carbon as property of the tree, right? Because it's automatic linked to the tree, and that's owned by the plant grower, which means carbon as their own property as well as the benefit from the tree. As the local people maybe understand that the carbon should be belong to them because they are plant the tree, and then the fruit from the tree should belong to them. Then the tree owner are responsible for the tree that they have planted, such as if a mango tree, right, on the perimeter of their house was plowed into the roof or yards of another person, the owner of the mango tree will be liable, which means have the obligation to take care of the, let's say, the yellow leaf of the mango tree, otherwise and the nearby house will be complain you. And then if carbon can be traded, it is the property of the tree and the same certainty as other type of the property, because now the government of Laos and the World Bank are signing the trading of the carbon in Laos PDR for more than 8.4 million tons of carbon, and the government of Laos can earn more than 40 million US dollar from 20 to 25. And then talking about the forest carbon ownership according to the law in Laos PDR here. When we let me explain a little bit. That the Laos PDR law system is the civil law, which means that the law will provide or create the right to you in terms of accept to or in terms of possessing of the property, or the right. If the law not allow or not create, you cannot have or accept to the right to use thing. So according to the article 227 of the 2019 civil code, it could be said that forest carbon is one of intangible property, because here we divide the property into tangible and intangible. So in my understanding, the carbon is one of the intangible property that can be traded, that can be how can I say, make a profit from them. And Article 103 of the forest law talking about the forest carbon trade, right? Trading between the tree owner and state representative or carbon trader. So which means that the forest law acknowledge about the ownership of the forest carbon of the tree trader, that they can trade and they can make a benefit from the forest carbon. So the two of law, as I already mentioned, they demonstrate about the state recognized the forest carbon of individual legal entity and organization. That is the that is the right, and the right can be traded to make sure useful for the tree grower. And when we looking at the public claim, right, for the forest carbon, there are a lot of claims, because when the Lao government and the World Bank sign, they said the forest carbon trading between the government of Laos and the World Bank on January 27, 2021 is considered important milestone for the forest protection and adding value to the forest resource. So after the government sell the forest carbon to the World Bank, and then the tree owner or plantation owner, they said that the government should share the benefit from the selling of the carbon to them. Otherwise, the forest carbon will not reach the agreement as provided by the Lao government to the World Bank, because from the 2020 to 2025, 5 years, the government of Laos allow 8.4 million tons of the forest carbon to the World Bank. So the local people said that if the government of Laos would like to reach the number of the quota of forest carbon as provided in the agreement, the government should share the benefit to the local people. Otherwise, local people will cut their tree, and then when the World Bank come to verify or come to calculate the number of the forest carbon will be not linked to the number that's defined in the agreement. And then when after we identify with the law and the real situation, is quite understand clear that the forest carbon also belong to the state for the natural resource or natural forest, but also belong to the local people or the tree planter who plant the tree for other purpose and other or for the generate to the carbon storage or carbon trading. That is the short presentation of my research. I hope that you can understand my language, because my language is not so beautiful. So thank you so much for your attention. If you have any suggestion or comment, we can discuss further about this. Thank you.
Thank you very much, Sypha. And I think that you were very well spoken and very well understood, particularly looking at those tensions of the benefits to communities from the carbon credit scheme. And I think you raised some really important points as countries start putting in place these agreements to get benefits from carbon credits and to trade carbon credits. So now we are going to turn to our question and answer session, and we've already received a number of questions, but if you have any further questions, please do add them in the Q&A box, which is on the bottom near the raised hand icon. Can I ask all of our speakers please to turn on your cameras? And I'm going to start with one of the first questions that was put in the box, which was whether or not these events are open to youth student leaders. And someone indicated that they would like to share this type of conference with other youth. And just to say on behalf of Ariel that absolutely this conference is open to anyone to register. We would very much encourage you to share the registration link with other law student associations and community groups and networks and anyone. And Ariel hosts together with partners such as UNEP and ADB and others throughout the year many such events which are always open to the public and welcome to have students to join those. So thank you for that question. Then I want to turn to our next question, which is open to everyone. And the question is, to what extent do constitutional laws of ASEAN states define the environment, biodiversity, and participation of stakeholders in decision-making in all matters related to the environment. And they've mentioned that it's a known factor that many constitutional laws are outdated. And this is a really interesting point, I think, because a number of countries globally provide constitutional rights to a healthy environment. So I wondered if someone would like to respond to this question, particularly about constitutional rights to a healthy environment and participation in ASEAN. So Jenny, did you want to take that first? Or Agung, sorry.
Yeah, thank you so much for the question. Really, constitutional law is very important in the protection of the environment and also provide the constitutional basis for the environmental defenders in their work to protect the environment. In ASEAN, for instance, 4 countries out of 10 countries have recognized the right to healthy and good environment explicitly in their constitution, which is really good to provide the basis. And the rest of the country do recognize the right to the environment, although they do it implicitly. But it doesn't mean that the statements of the rights in constitutional law really outdated, because it's continually interpreted by the courts. In Indonesia, for instance, we do recognize the right to good and healthy environment in our constitution, and then this statement then set out again in the 2009 Environmental Protection and Management Law, which is provide the basis and how the rights to good and healthy environments should be implemented on the ground. And once the right to healthy and good environment exercised by environmental activists or local community, and they get challenged by corporation, for instance, then we come to the anti-slide provisions. That's the idea, how the constitutional law then provide the basis, and then later on is set out within the law dealing with the environment, and also within Indonesian law dealing with the environment, the rights to healthy and good environments not only give the procedural rights set out in the Aarhus Convention, for instance. Indonesia also adds another versions of the right to good environment, which is the right to have environmental education. So this is very important, because the right to have environmental education is expected to increase the awareness of the citizens about the environmental problems we're facing right now. So that's why when they're aware with the environmental problems, they would do their part in order to protect the environments. That's, I guess, the importance of the constitutional law in protecting the environment, because the legal base, the foundation for not only for the environment, but also for the vendors to do their job.
Fantastic. Thank you so much for that wonderful summary and response to that answer. Would anyone like to add to what Agung has shared?
If I may, just briefly, so there is also one country that has inherently recognized the right to a healthy environment in their case law, and that is Malaysia. I would just like to reiterate the importance of having a right to a healthy environment in the Constitution, because it now gives standing to various plaintiffs on environmental issues without having to prove its link to a particular human right. So for those countries that only recognizes protected rights that are then applied to environmental cases, they will usually, to bring up the, to secure locus standi in court, they would have to prove some linkage between the violation, between the environmental harm and the violation caused. And that can sometimes be very difficult, but with a right to a healthy environment provision in the Constitution, that let's say obstacle is removed. So I do think that it's progressive in of itself, to have it explicitly recognized. But of course, more work is needed to clarify what it means in practice, and how the right to a healthy environment in the Constitution can be enforced in environmental law or in environmental contexts.
Thank you, Victor. And I've also just popped in the chat box a link to the report of the Special Rapporteur on Human Rights and the Environment, who did an assessment of the legal recognition of rights to a healthy environment globally. And I've just extracted from that a really great visual of all of the countries' recognition at the regional level as well as the national level that might be useful. Okay, so I want to go to the next question, which is a very easy one for Chenny. Somebody has please asked for the reference to the Pring and Cannon book, I think it is, that you referenced on slap suits. So Chenny, if you want to provide that in the chat box, that would be great. And there is a follow-up question here that I want to ask Agung and Chenny, and that is what role national human rights institutions can play in strengthening the implementation of anti-SLAPP provisions? And are there any good practices in the region of NHRIs upholding anti-SLAPP? So over to the two of you to respond to that.
Okay, I'll start first, and Mr. Wardana can just adding about from what I said. So it is, I think we see that there's a very good opportunity for the National Human Rights Commission right now, because recently in Indonesia, they just published a standard norm of procedures for the protection for human rights defenders. And I think that can serve as a basic, understanding that firstly, they have acknowledged there's an attack towards the human rights defenders, and this will, like expand the territory of SLAPP to not only in ecological aspect, but also to recognize human rights in general. That is the first good step. And the second, we think that this can provide a good recommendation for from the National Human Rights Commission of whenever there is a case that is being handled by the court. Although unfortunately the recognition, the recommendation is not served as binding, and it has to be like considered by the court or by the other institution. But I think it's a great step for firstly recognizing that there is this case happening, and there's and there's nations that is also have understand and also take this into consideration. Maybe Mr. Wardana would like to add something.
Yeah, I just want to follow up from that one. Before that, the reference for the Pring and Cannons, of course, the title of the book we know already as Getting Slapped. It is Getting Slapped, and then I got a little bit forget about the subtitles. Chenny would like to help. Getting Slapped for Speaking Up. Sorry, the Getting Slapped for Speaking Up. That's the title of the book.
So,
okay. Okay. With regard to human rights commissions, of course, right now in Indonesia, there has been a debate on how to prevent SLAPP cases from the beginning, because we cannot wait the SLAPP cases come through the court and then get the final decision by the court, because the chilling effect will be occurred in the first place. Of course, we need to prevent the chilling effect to take effects for the defenders. That's why the idea is that we need another layer how to prevent this by involving not only the law enforcement institution, but also other institutions such as human rights institution, human rights commission, one of the promising institutions that can be bring to this prevention. And the other idea is that to bring the Ministry for the Environment to give recommendation whether a case can be considered as SLAPP cases or not. So for the second option, by involving Ministry for the Environment, There has been a debate as well, because we now Indonesia is a little bit skeptical with the Ministry for the Environment in dealing with environmental cases. That's why if we bring this, give this opportunity for the ministry to decide whether a case is SLAP cases or not, it would provide another burden for them, besides the limitation as well, and also limited resources as well for them. Then the most feasible option right now for Indonesia is to give the opportunity for the Human Rights Commission to decide, to give recommendation. If a case that can be identified as SLAP case, then we ask for the recommendation from the Human Rights Commission in order to bring whether or not this case is SLAP and whether or not this case can be gone through the court. If it's a SLAP case, then Human Rights Commission can provide recommendation to stop the case, because the chilling effects and also the violation of the right to participate for the citizens. That's the idea right now emerged from the discussion, how to bring the anti-SLAP provisions more effects before waiting to go through the courts. That's from me. Thank you.
Thanks. Fantastic. We have a large number of questions now, so I'm going to pose a few more questions, and if I could ask everyone to sort of try and be as succinct in your answers as possible. I'm going to direct the next question to Katia, and this question is, what can special rapporteurs do to address the risks to environmental human rights defenders, and what are the practical impacts that the actions of SRs can have at the national level?
Thank you very much, Georgie. I think this is a very important question. I mean, definitely UN special rapporteurs, but I would say more broadly, the international human rights mechanism, which includes the universal periodic review of member states, but also the reviews, regular reviews through treaty bodies, can play a critical role in strengthening the role of environmental human rights defenders. When it comes to the special rapporteurs, of course, this can be done in a number of different ways. Can be done through feeding to the various mandate holders. And when it comes to the role of environmental human rights defenders, there are so many mandates that come into play beyond the immediate connection, for instance, to the special rapporteur on the human rights defenders, on the special rapporteur on environment and human rights. But let's think, for instance, of others like many even women, the role of women. And here I would like to spend a specific reference to the impact that of the relations that we have mentioned so far, the specific one on women environmental human rights defenders. So by engaging them with regular analysis and update on the situation on the ground, and in return allowing them to have a more up-to-date vision of what is happening, in particular to a number of emblematic cases that we are all familiar with in the region. But also what we know is that there are specific challenges in getting up-to-date information on the situation on the ground in rural and marginalized areas, where, especially now in the context of COVID, the role of the digital divide is making even more challenging to have that regular analysis and feed. So, and of course, through a number of special rapporteurs call for open contributions to their regular reports to the Human Rights Council and the General Assembly. And by feeding into those reports will be then will be crystallized in both analytical overview of what is the situation on the ground, but even more importantly, very concrete recommendations, which most of the reports target specific duty bearers. So there are recommendations directed at government, at the private sector, the judiciary, on the role we were discussing now, the role of national human rights institutions. So those recommendations are a very strong avenue on which we can anchor, all of us, our advocacy, both at the global level, but equally importantly here in the region. Of course, our office This is part of the regular work that we do, supporting engagement with the international human rights mechanism, of course, included special procedures. And we are always very happy to extend all the support we can to sort of be a connecting element, a bridging element between environmental human rights defenders here in the region and the special procedures. Thank you.
Thank you very much, Katia. And I want to ask the next question to Sypha. Sypha, what are some possible strategies and ways that we can impart environmental legal information, and particularly the legal research that you've conducted, to the grassroots level of society? And how do we ensure that there are benefits to society?
Yes, thank you for your question. I think that is a very kind of very tough question, because when we talking about the generate, or let's say that the making the profit to the local community is very hard to talk about that. But in terms of in my paper that I just present to you, I observed that from the, for example, from the carbon trading, they provide the benefit sharing to the local community. That is the real forest protector, right? Then allows 75% of the income will be generated to the local community. Mainly the village, to the village in the very down local authority in Laos, because our local authority here, we are talking in 3 levels, I mean the village, district and province. So that is the paper that I observed. In terms of access to the information for environmental law or environmental law information is quite hard, because if you can speak or read loud is okay, but in terms of cannot is quite difficult to accept. Yes, that is my question. Thank you.
Thank you, Sypha. Would anybody else like to also respond to that question of what are some strategic ways to ensure that information on environmental law is shared at the grassroots level?
If I can just add an important element that is part of this rights-based approach on working on climate change adaptation, and that is to make information available first and foremost in the languages spoken by the different communities. And the information that is provided needs to also be simplified, essentially, so that everyone can understand the information and the risks of the risks that could result from, for example, the implementation of a climate change adaptation program. So, and that's something that I've been working on quite extensively with SCI, for example, in their regional environmental events, trying to translate the information that we are producing into the local languages and the languages spoken at the local levels.
May I?
Yes, please.
Yeah, of course, delivering environmental information to the grassroots level is very tough job. Of course, we know that environmental issue is very complex, involving science, technical terms. For instance, how would you translate climate change for rural community in Indonesia? Very hard for them to understand the language. That's why we need a broker here to be an intermediate group to connect this technical language into the grassroots language, so ordinary people's language. This makes the work of environmental NGOs very important, and academics who wrote it in local communities will work very important. But right now, their work has been limited due to the shrinking of democratic space throughout the region, especially through the criminalizations and also murder and so forth. That's why the right to access information is very important, and the roles of NGOs and environmental activists is also important because they are the brokers for providing the language, the international language, because local community are facing language barriers to understand what was happening at the international level, then how would this affect their local community? That's why NGOs work really important. That's why the protection of the NGOs in being the intermediate groups for connecting international community and local community is very important. That's why they need to be protected.
Just adding something. Yeah, so aside from the method, I think adequate time for the community to digest the information is also important. And also in terms of slap victims, I think giving an adequate legal assistance for them, and also to continuously ignite their fire in order to not in order to ignite their activism is also important, so that they won't lose their first fight, which is a fight for environmental rights, and you know, just focus on the slave cases that happen to them. Therefore, to ignite their fire is very highly beneficial and also important things to do for the activism to keep going for the environmental rights fulfillment. Thank you.
Fantastic, thank you. And I think this is going to connect to the next question that I want to ask. And I'm going to actually, because there have been so many great questions, I'm going to ask two questions together. And I'm going to ask everyone to give like a 2-minute answer to one of these elements of these questions as a summary and a final thoughts. But the questions is what are some examples of a country which has done a good job in protecting the action of environmental defenders? So what country could be an example? So we know, for example, Mongolia has the law on human rights defenders now, but are there other countries that could provide a good example? And I know other people have provided some information in the chat box, such as from the Philippines, they've talked about the Riti of Kalikasan and different constitutional rights of countries in the region. So yeah, just any good examples that you may want to share. The second element of this question is, do you think that in certain domains, giving legal existence or rights to the environment would make the work of environmental defenders more effective? So for example, giving rivers in New Zealand rights, the case of the Wanganui River. So do you think that giving legal rights to the environment would make the work of environmental defenders more effective? Two very extensive questions, really, that we could answer for a long time, but please just 2 minutes each, and then we will close this session. So can I start with Sypha? Sypha, over to you.
Yes, for the first question, I think that the goals of the let's say the goals efforts of the government of Laos is try to protect the environment, but a lot of law and regulation, let's say, or sub law was promulgated to deal with the environmental issue. For example, the environmental law, the water law, and also the climate change decree, Prime Minister decree, in terms of dealing with the environmental issue. But for the second one, I am not sure about this, because the thing that we are trying to do is quite, let's say, in terms of Laos, is quite difficult for balance between what the government would like to get for the investor, for, let's say, for example, but it's quite complicated to talk about that. That is from my side. Thank you.
Thank you, Sypha. Katia, over to you.
Thank you, Georgie. Thinking about specific reference to good practice now in terms of constitutional rights guarantees, there are definitely a number of examples in the region that we can look at. At the same time, the important space to watch is how those rights are realized and protected, which is always the or oftentimes the weak part of that chain. So when we look at whether it's constitutional rights, legislation or policies, some of them can be really progressive and advanced and reflect commitments and obligations that those governments have made, also vis-a-vis international human rights law and frameworks. But then how those are translated into practice, how they become a practical way for environmental human rights defenders, for instance, to be empowered and to be able to play their critical role free from fear, pressure, or exposure to human rights violations and abuses. I think that is really the pressing question, which is upon all of us to continue giving answers to. In terms of the second question, I would also, look at it as a balancing act. For sure, having a situation where access to natural resources, for instance, is regulated in the way which is, prevents to the fullest extent exploitation of resources. There included, of course, access to water, rivers, or lakes, or sea. However, in how many declinations we would like to look at it from a natural resources perspective would help. But at the same time, I think if we look at it from a human rights-based approach, it should be first and foremost a responsibility of duty bearers to make sure that all the right holders are in a position both to benefit from those resources equally and in a way that no one is left behind, and without any form of discrimination. And again, I want to come back to the role of environmental human rights defenders, which is our point of departure. So I really look at this as a very important question and a balancing act, and one which requires concerted efforts by everyone.
Thank you, Katia. Okay, so quickly, just 1 minute each for Victor, Agung, and Chani. Victor, over to you.
Well, I think Katia covered most of the bases, so I will do this issue some justice and not repeat many of it. But some of the good practices that has come from, for example, Thailand, is the amended 161/1 amendment of the Thai criminal procedure, which allows judges to dismiss and forbid, for example, the filing of complaints by a private individual if this is done in bad faith. I mean, we have similar good practices in Indonesia, the Philippines, but the problem, as Katia rightly mentioned, is the enforcement. So we still haven't seen judges being able to incorporate this into their judgments on issues that relate to environmental rights defenders. And as for the rights of nature in general, I do agree with Katia once again. It is a balancing act. Of course, it's very useful to have a standalone right for nature or a standalone right for the environment, because it gives a broader group of people locus standi. But at the same time, is it politically feasible to have, for example, rights to nature, which doesn't really exist in human rights law per se? But that's, of course, a question that we can address on another occasion. Thank you.
Yeah, thanks, Victor. Agung, over to you.
Yeah, thank you. I couldn't help myself to be skeptical in this regard as a scholar, and at the same time as an activist, I need to be very optimistic as well. So otherwise, what we have done, it would be meaningless, right? At least there's some optimism need to be there in order to keep pursuing betterment. Of course, in the regions, not all stories are good story. The good one, there's some problems in how the environmental defenders are being silenced, intimidated, and also being sent to prison, even assassinated. And we know that. But also, we need to be balanced our point of view. There also some progressions toward protection. For instance, we are now free to talk about the protection of environmental defenders in Indonesia. We still have at least democratic space to talk about and also to do our advocacy, to change the regulation, to do legal reform in order to provide a better protection for the environmental defenders. At least that's a good sign. There's a progress. And also, I agree with Victor's in some countries in the region, there are also good examples of cases where the judge use their roles to exercise judicial activism, which is really good. And in terms of giving the legal rights for the environment, yeah, I'm a bit skeptic in this regard because when we talk about human rights itself, is still contentious, a very controversial issue in this region. Protection of the protection of human rights right now in the region, it's also a very controversial issue. So many human rights violations in the region. Not to mention when we talk about the legal right to ecological entity for the mountains, rivers, and so forth. So I guess we need to deal, I'm not going to be very anthropocentric here, but we need to deal with the human right first, because this will be the basis in how we can protect the environment, because I believe that the environmental problem we face right now is the problem of power among humans. So that's why we need to deal our problem within human first, and protection of human rights will be the first step to deal with environmental problems. Thank you.
Thank you. Thank you. And Chenny, you have the last word.
Okay. Okay, from my point of view, Philippines has set a good sets of rules or regulations to protect slave victims, even recognizing the protection from administrative court that is not implemented in other countries. But for the effectivity, I think it needs further field research, of course. But from the article that I read, some environmental human rights defenders state that the environmental rules of procedure, which is the product, has made them not afraid to fight and keep going for their activism. And I think that's a good point of statement to see that there's actually a good cost from derived from the environmental rules of procedure. For the case, I think for my presentation, I have set a good decision in Indonesia in both civil and criminal realm. I think that can be served as a good example for case handling. For the second question, it's rather philosophical, but I think from the Christopher Stone, we think that there's already a concept of guardianship that enables environmental agency or institution to act on behalf of environment. That I think it indicates that there's a recognition of environmental domains itself, although not explicitly. And I think in the case of Indonesia, I think it still serves as a good approach for now. But yeah, we will see in the future, and I think it's need further elaborative and philosophical research, of course. Thank you. Back to you, Georgie.
Thank you very much, and thank you to all of our speakers for this incredibly thoughtful, insightful panel that we've had today. Thank you everyone for joining session 1, and we will now ask you to head back to the lobby and head over to session 2 for an incredible discussion on environmental public interest litigation. So thank you once again, and we will see you in the next session. Bye.
Bye. Thank you so much.
Bye.
Bye.